Hello everyone, welcome back. We're going to start. I'm going to ask the speakers to have only 25 minutes so we can be on schedule. And first I'm going to give the word to Maribel González from University of Pompeu Fabra, well known by everybody here. So your turn, Maribel.
Okay. Thank you very much. As we all know, and it has been repeated this morning, it has been discussed whether courts can or even should guarantee social rights. Many scholars have consistently rebutted the main objections to the question of social rights, but still courts tend to play a lesser role when it comes to social rights and try to anchor their protection in other rights or principles of the legal systems. Luxembourg is no alien to these techniques. In this regard, during the last years, Luxembourg has had the chance to rule on the impact of the euro crisis on social rights in cases related to national measures approved to tackle the crisis, which were in contradiction with either consumer protection or with the balance between the freedom to conduct a business and labor rights. In some of these cases, the Luxembourg court has developed a kind of indirect protection of social rights in line with this traditional role of courts in cases regarding social rights. The cases I am about to deal with have in common, first, that the court relies on economic rights in a strict term, since they are rights entrepreneurial in character in a context of trade liberalization, which makes them intrinsically different from the ones that enhance the opportunities of the economically disadvantaged. The prime addressees of EU consumer law and of the freedom to conduct a business are the flexible, self-standing, self-conscious market citizens who make the EU a competitive economy. They pursue fair access conditions, competitiveness in the internal market, whereas social justice is result-oriented. They are definitely different from welfare state-inspired concepts. Second, in these cases, the court does not elaborate on the social rights scope. As a matter of fact, in most of the cases, social rights are not even mentioned. Still, the court made interesting statements on the limits stemming from EU law that protects social rights to a certain extent. The cases regarding consumer protection are the ones dealing with the compatibility of the Spanish foreclosure procedure with the directive on unfair terms in consumers' contracts in the frame of the burst of the housing bubble in Spain. As is well known, the Spanish Code of Civil Procedure limited the debtor's possibilities to raise objections in mortgage enforcement procedures to cases of error in determining the amount due, to cases of extinction of the security or secure obligation, or to cases in which another mortgage have been previously registered. Of these cases, any dispute on an unfair contractual term have to be assessed in legal proceedings separate from foreclosure proceedings, and without ever having the effect of staying and terminating the judicial enforcement proceedings. Thus, if a contractual term was considered abusive, compensation could be granted, but by then, the home have probably already changed hands. In the frame of the economic crisis, an ordinary court decided to ask to the Luxembourg court whether the Spanish Code of Civil Procedure was an impediment to consumer rights. It was also asked whether several clauses in mortgage contracts could create a significant imbalance to the detriment of the consumer. On 24 March 2013, the Court of Justice stated that the directive precludes any legislation which does not allow the domestic court to assess whether a contractual term is unfair in order to grant interim relief. Furthermore, it pointed out that this applies all the more strongly where the mortgage property is the family home of the consumer. Besides, even though Luxembourg did not establish whether the terms at stake in the main procedures were unfair, it elaborated several guidelines to determine its unfairness. This judgment had a tremendous impact on the Spanish legal system. In fact, it influenced the Debtor's Mortgage Act passed on 14 May 2013. Several provisions of this second act were particularly controversial, and further preliminary rulings related to the mortgage law were raised. The Sanchez-Morcillo case must be highlighted from the social rights point of view. Luxembourg considered it necessary to rule under the expeditive procedure because beyond the number of affected debtors reported by the court, the risk of the owner of losing his main dwelling puts him and his family in a particularly fragile situation. The importance of the home bears also weight in the judgment because the fact that the case concerned the family home aggravated the inequality between the parties. In this regard, Luxembourg considered it necessary to scrutinize the disputed provision within the context of the whole Spanish mortgage system enforcement scheme. In the court's view, the Spanish procedural system, taken as a whole and in the manner applicable to the proceedings, exposes consumers and plausibly their family to the risk of losing their dwelling. Luxembourg actually assessed that the Spanish Mortgage Act placed the consumer in a weaker position compared with the creditor. This imbalance among parties aggravated the difference between consumer and supplier that EU consumer law aims at redressing. Furthermore, it was contrary to the principle of equality of earnings, which is contained in the judicial protection guaranteed by the Charter. In a nutshell, the Luxembourg court made clear that the Spanish legislation had not struck a proper balance between debtors and owners in foreclosures proceeding. The judgment took into account the consequences on the mortgage informants. In fact, it is plausible to consider that the right to housing strengthened the consumer's protection to the extent that the intrinsic value of the goods put into question, in this case a family home, determined the need of a stricter judicial scrutiny. Thus, the balance between the rights of both parties is not alien to the need to afford protection to social rights. Therefore, the scope of economic rights, the consumer protection, is amplified and particularly strengthened because indirectly it's protecting a social right. Still, it's not rooted in social redistributive justice, but in asset justice. In fact, the importance of the home bears weight in the judgment, but its protection was not configured as a fundamental right. Right to housing is an important element in order to determine the actual scope of another right, but it's not a right on its own. Still, is a more nuanced balance between the social and economic rights that we can also find in cases related to the freedom to conduct a business and labor rights. One example being the Iraklis case, as was mentioned. As is well known, Iraklis produced semen in 3 plants in Greek and wants to shut down one of them. It seeks ministerial authorization as required by the Greek legislation. The Minister of Labor refused the request, relying on a Greek law, according to which collective redundancies are to be considered on the basis of the conditions of the labor market, the situation of the undertaking, and the interests of the national economy. The court explicitly stated that, as is apparent from Article 3.3 of the Treaty on the European Union, the EU is not only to establish an internal market, but it is also to work for the sustainable development of Europe, which is based in particularly on a highly competitive social market economy aiming at full employment and social progress, and it is to promote social protection. Furthermore, the court stated that the EU has not only an economic, but also a social purpose. Such statements mark a new tone of the court when it comes to the balance between economic and social goals in this field. The role of Article 3 of the Treaty on the European Union must be highlighted because if it were read together with the Charter, it might allow for the granting of an adjudication on waiving social rights. Furthermore, the Court of Justice reminds us that the freedom to conduct a business is not absolute, as it is clear in the Charter, but must be viewed in relation to its social function. This is not new, but even in cases in which the social goals played a role, the Court also gave weight to economic rights. I'm thinking about the Spesino case regarding public health, in which in the reasoning is the public health is important, but also that is controlling the spending on public health. Both elements are taken into account by the court. In Iraklis' case, social gaps seem to trump over the economic ones on its own. In fact, the court pointing out that the rights enshrined in the Charter might be limited to protect the rights and freedoms of others. As regards some rights and freedoms, it is to be noted Article 30 of the Charter. Thus, Article 30 could be given weight regardless of its actual wording, that there is so much discussion about conditional. This is a non-imperative right. Therefore, Luxembourg seems to admit the need to determine the scope of the freedom to conduct a business, taking into account social rights enshrined in the Charter. As seen before with the consumer protection, a social reading of an economic right can provide an avenue to protect social rights. Nevertheless, it must be noted that the Greek law was considered to be not compatible with EU law, since it was not proportional. The court neither dwelled much on the need to protect Article 30, nor took into account other rights, such as the ones enshrined in Article 27. Still, it should be stressed out that social objectives can be taken into consideration to limit economic rights. In fact, the goals of the Greek law were considered compatible in abstract with EU law, which might lead to a more fair balance between economic and social goals if this case law were developed. Furthermore, the protection of workers is a legitimate aim, and such reasoning might impact on the scope of fundamental freedoms, because it might lead to a set that a difficult economic situation that diminishes EU social rights might legitimate an active policy, impinging upon the right to economic initiative, but not the other way around. Member states indeed must comply with social entitlements contained in EU law regardless of the economic situation, as Luxembourg has stated in the case Hogan and others regarding the Irish implementation of the directive on the protection of employees in the event of insolvency. In the field of consumer protection, we have the Gutiérrez Naranjo case, in which the serious economic repercussions of the judgment, a leak by the Spanish government, did not trump over consumer protection in mortgage proceedings. And both cases were decided in the midst of the crisis, one in Ireland or in Spain, who were in the midst of the crisis. So it seems that the reasoning does not work in both ways, which is important. If the court develops this scale law, really briefly sketched, it might move towards a model of justice that probably cannot be equated with social justice, understanding as such the one deriving from the workers' movement, but it sets aside a libertarian concept of justice characterized as the absence of responsibility for distribution of wealth in the society. It will embrace an understanding of justice close to equity, which aids in counterbalancing the market freedoms. And here I'm following with Miklis, I hope I say it right. So at the very end, social justice that not only pertain to transfers of income, but it relates also to matters of trade. Still, this optimistic view has to be confirmed by Luxembourg, because as already said, Iraklis might be a Pyrrhic victory for social rights. Not only for the outcome of the judgment, that it speaks volume, the outcome of the judgment, but also because, as scholars have pointed out, if the Greek government wants to redraft the law, it has to do it in cooperation with the Commission, the ECB, the INF, and the ESM. In fact, all this case law of the Luxembourg court is a step forward to build an indirect protection of social rights by taking them into account in cases regarding economic rights, but it might be not enough. It might be even antique, thought for a former scenario. Currently, in many cases, the market discipline has been substituted by public discipline through conditionality, which is especially demanding in countries in economic distress. So in all those cases, the commented case law could simply not be enough. In fact, if we return for a minute to the protection of the right to housing through consumer rights, we have to accept that a reduction of the mortgage payment is not good enough in many cases. In this framework, for instance, in the midst of the crisis, several Spanish regions passed particularly far-reaching laws on the right to housing. But the Spanish Constitutional Court declared the provisions of those regional rules unconstitutional. Those decisions highlights the current dilemma of these rights. Let me tell briefly one of the cases. On 2013, the Prime Minister challenged the first of those laws, that was from Andalusia, a decree law, before the Constitutional Court, and also asked for its suspension. His main allegation was the fifth review of the financial assistance program in Spain, monitored by the Troika. According to this report, and I quote the statement, regional laws aimed at alleviating the social problems related to foreclosures may even endanger financial stability. The Constitutional Court considered that the Troika is composed of highly specialized institutions which are independent from the parties, that its statements are not mere assumptions but provide evidence for the courts to decide. The law was suspended. On May 2015, the Constitutional Court delivered the final judgment. The court stated that Spain had to stabilize and reorganize the banking sector, the mortgage scheme being crucial to achieve this. The Mortgage Debtors Act, approved by the national government, by the national parliament, has ascertained the scope of the right to housing, which does not endanger the mortgage schemes. Further measures, according to the court, might change this balance. Therefore, the Andalusian rules and all the other similar regional rules were declared unconstitutional. This reasoning was built upon a letter sent by the Commission to the Spanish government on June 2013. According to this letter, regional measure goes further than a balanced approach that should reconcile the necessary protection of the most vulnerable families with the need to preserve financial stability. The resemblance with the Constitutional Court reasoning is astonishing. However disappointing, the judge came as no surprise. It's what illuminated that the Constitutional Court considered that the Troika statements were evidence. In my view, the court reasoning confirms three assessments. First, courts are extremely different regarding international settlements contents of economic crisis. The global economic crisis fueled the decision. Besides the compliance with the financial assistance, the excessive deficit and the macroeconomic imbalance procedures were intertwined and indirectly strengthened. Of course, the Constitutional Court was aware of it. Second, the ultimate strength lying under international bodies' recommendation on economic matters should not be underestimated. Third, housing as an investment asset trumps over housing as a social right. The Spanish case bears witness to this asymmetry. In the frame of the financial assistance for decapitalization of the banking system, the Spanish state provided 61.5 billion euros and only 2.7 billion have been recovered, according to the central bank, Spanish central bank. According to the judiciary, only in 2013 there were around 82,000 foreclosure proceedings. Furthermore, it has been estimated that only 7.6% of the households with all the members unemployed would be considered a vulnerable group according to the steep requirements of the Mortgage Debtors Act, the one that the Troika, the Commission, and the Spanish Constitutional Court considered to be the most that could be done for the right to housing in the frame of the financial assistance. This is not to disregard the decisions of the court that I have briefly sketched, but to point out that they are not enough. New challenges are on the table, and new avenues must be explored. The EU economic constitution is increasingly eroding the national constitutions, which are quite defenseless towards economic recommendations stemming from EU institutions in times of distress. Not only the social rights standards have been lowered, but the balance among national players have also been deeply changed within the states struggling with the crisis. A most firm defense of social rights is needed. The Lisbon Treaty incorporated the Charter, the objective of a social market economy, and the clauses in Articles 9 and 10 of the Treaty on the Functioning. Such provisions could and should influence the balance struck between economic and social goals. Obviously, the interpretation of Luxembourg of social rights depends on the political agreement on the field to a large extent. The traditional strong objection regarding adjudication of social rights carry particularly weight when it comes to the Luxembourg court. Still, social goals must be taken into account by the Luxembourg court, and the indirect protection of social rights might be proved to be a fair way in many cases, since it is anchored in well-settled principles of EU law, and besides, its spillover effect should not be underestimated. However, as already said, it has to be firmed and extend its reach. In this regard, the European Pillar of Social Rights that aims at improving the social dimension of the EMU, at the very least, seems to imply a political shift towards a more social outlook and could strengthen a new narrative in the EU. Its final impact, of course, will depend on whether the measures envisaged by the pillar are implemented, but it could influence the case law since it could strengthen the position of the court in those cases. There are more documents in which it can rely to develop social rights. For instance, if we think about national courts that were quoted this morning, the Italian Constitutional Court had explicitly relied on international treaties on social rights during the crisis in cases in which the courts has declared unconstitutional measures adopted to tackle the crisis. So this a case on convention has quoted the Convention on the Rights of Persons with Disabilities, a regional case, and there's another, I think it's a national case on collective bargain, in which that has quoted the International Labour Organization, which is not a tradition of the Italian Constitutional Court. So actually, new avenues can be explored by courts, and national courts are doing it, some of them. The narrative of the social rights in Luxembourg, in any case, is very important for the protection, especially in the current scenario. In fact, the court has also protected social rights with this balance between economic and social rights in cases regarding austerity measures, but without mentioning social rights. Pujante Rivera case, for instance, a Spanish case, the court declared that the interpretation of substantial changes in working conditions contained in the Spanish Royal Decree Law was not compatible with EU law. According to the Court of Justice, the unilateral and significant change of essential elements of an employment contract for reasons not related to the employee falls within the definition of redundancy. So in this regard, the directive intends to ensure comparable protection of employees in the member states. The reasoning of the court seemed to imply that allowing employers to reduce their costs in a member state by lowering the working condition standards contradicts EU law. Interesting enough, that is precisely what the Spanish government was trying to achieve, to increase Spanish economic competitiveness by diminishing labor rights in line with the recommendations drafted by the Commission in 2014 to tackle the Spanish macroeconomic imbalances. So the Commission asked for this reform to be passed. That's why this judgment is quite interesting. However, the Court of Justice did not mention the social rights involved in this case, not even once, which is unfortunate in my view. A fundamental rights narrative, of course, does not necessarily lead to increased popular support for a project. It might indeed lead to the opposite results. We are not so naive. In the framework of a growing Euroscepticism, a robust EU fundamental rights narrative could put into question the legitimacy of the EU before many citizens. But the opposite trend cannot be disregarded. If the Luxembourg court does not protect fundamental rights, its legitimacy could also be undermined. In this regard, if the citizen is, as Halter put it, a consumer, an economic achievement keep us together, a fundamental rights narrative could even jeopardize the Luxembourg narrative. However, if the EU is not only a community of states longing to improve their market, but as Pernis put it, citizens' community funded on shared values, also social values, which are enshrined in the treaty and in the charter that the EU have promised to protect, then all the institutions must stand for social rights and have to protect them in a clear way. Why not in red, but in a clear way, and to take into account all the challenges that now social rights are facing. That's why my presentation is whether this balance is realistic, and especially if it's not. Thank you.
Thank you, Maribel, for this interesting presentation. We're going to discuss later about if it has been realistic enough, this protection in the EU. First of all, before continuing, I would like to remind you to please sign the authorization for recording, which is this one, if you have. Thank you. And now, the next speaker is Paul Dermine from Maastricht University. He's going to talk about reconciling fundamental rights and the new economic governance of the Eurozone, the case of equality and non-discrimination. Please. Would you like to change places so you can?
Yeah, up to you. That's fine.
It's here. This one?
Excellent. All right. Well, is it animaciones? No. Presentaciones. Excellent. Well, first of all, I'd like to thank the organizers for giving me the opportunity to join the discussions today. It's a really great pleasure to be in Barcelona, and I'm very grateful. With my presentation, I'd like to offer some reflections about the position and the status of fundamental rights under the post-crisis economic governance system of the Eurozone, under the various policy mechanisms and processes that constitute this new system. First of all, I'll briefly assess the situation that currently prevails under the existing framework, that is the existing secondary law instruments, and also the practice and the methodologies that the institutions have elaborated over time. Secondly, I want to come back to an issue that we touched upon this morning, and that's the question of the relevant fundamental rights instruments that actually apply to this new economic governance system. It's not entirely clear, for example, whether the Union fundamental rights regime is actually applicable at all to this new socio-economic governance system. So I want to offer some reflections in that regard. And finally, I'll try to outline a way forward and suggest a few avenues for change through which the constitutional position of fundamental rights may be enhanced and through which their sustainability on the long term may be bettered. The approach that I favor is a rather general one. I will talk about fundamental rights in general, but I will also, whenever necessary, provide illustrations and elements that will enlighten us from the perspective of the principles of equality and non-discrimination, hoping that this will be useful. And finally, I should also acknowledge that parts of this presentation rely on collective work that I conducted with a colleague from Belgium, Olivier de Scuter, and which resulted in this contribution, the reference of which has been inserted here. All right, first element, which has already been touched upon, but I think we can never sufficiently emphasize it. It's, well, the ability of the current system of economic governance to dramatically and systematically impact general levels of fundamental rights enjoyment across the EU, to impact the member states' ability to respect, protect, and fulfill fundamental rights. A few remarks in that regard. It's first of all that this is a widespread phenomenon, so we most often have in mind the paradigmatic examples of build-out countries, but this is a phenomenon that regards the entirety of the Eurozone, even those member states under the most standard prongs of economic governance. The second element is that, well, this phenomenon concerns the entire spectrum of fundamental rights. Again, we most often have in mind social and economic rights, but more classic civil and political rights are also at stake. And of course, I already pinpoint equality and non-discrimination. We have a lot of scientific documentation, a lot of judicial pronouncements about the dramatic effect of crisis measure of the economic governance on equality and non-discrimination. And more particularly, it has been shown that economic governance disproportionately impacts those groups that are already vulnerable or systematically discriminated, be it women, the less wealthy, the young people. We've talked about certain pronouncements from the European Committee of Social Rights finding discrimination on the basis of age. So clearly this is something that is at stake here. Now, when looking at the status, at the position of fundamental rights under the current economic governance system, we can first have a look at the overarching narrative, the overarching strategy of economic governance. And of course, it's not surprising that fundamental rights fulfillments are never evoked, either as a direct nor as an indirect policy objective. So economic governance is structured around a set of macroeconomic goals, and fundamental rights are rarely evoked in that regard. And more importantly, on the part of the EU institution, there is an official claim of neutrality. Economic governance would not impact fundamental rights for the main reason that it is not designed to. Economic governance is about the collective pursuance of policy goals, of collective policy goals, of collective policy targets, but member states retain full discretion when it comes to choosing the means through which these policy goals are to be pursued. Of course, we know that in a post-crisis era, the European Union has gained tremendous influence on policy designs, on the definition of the right policy mix, an influence that so far remains unacknowledged. So the reforms precipitated by the Eurozone crisis have in a way blurred the accountability lines in such a manner that reforms that are adopted at the national level can with difficulty be allocated to the actual author. Turning now to the methodology of the EU institutions in the field of economic governance and the status and the role played by fundamental rights in that regard. Well, we can distinguish between what I call extreme economic governance, so this exceptional regime that was devolved in parallel with this new financial assistance function, which is in many regards quite exceptional. Well, what roles do fundamental rights play in that context? The first observation that one can make is the fact that the workings of the Troika, now we say quadriga, are particularly obscure and opaque. And it's very difficult to know how exactly policy is being designed in that framework, but we have no strong elements suggesting that fundamental rights and the preservation of minimal levels of enjoyment are relevant elements that structure decision-making. Of course, there's been in 2015 a relative improvement. We've talked about the socialization of economic governance, the pledges made by the Juncker Commission, and indeed in 2015 the third Greek bailout was subjected to a social impact assessment. So that's a rather welcome move, if only because it suggests at least that there is awareness on the part of the EU institutions, but this impact assessment has been heavily criticized by other international organizations, by external observers, as being merely an ex post exercise, a box-ticking exercise that simply validated a posteriori the options favored, but without seriously questioning any of the orientations that had been taken. A final element when it comes to extreme economic governance is of course the Ledger advertising ruling, which intervened in 2016, in which the court clearly stated that EU institutions remain bound by EU law and by the Charter in any kind of circumstances, even when acting as a borrowed institution by external organizations. So of course we haven't had any new bailouts since, but what we hear from the institution is that the Ledra ruling was quite a wake-up call for them and may have transformed the internal workings, at least within the Commission. When it comes to standard economic governance, so that is the European semester, the Stability and Growth Pact, the macroeconomic imbalance procedure, again, there's a general obscurity as to the actual methodologies that are favored either by the Commission or by the Council. So there has been a certain opening of the process with the Juncker Commission, with the socialization of economic governance, but still nothing from which we could infer that fundamental rights are duly taken into account in the process of deliberation, in the process of policy making. So impact assessments are omitted for the core outputs of standard economic governance, so the CSRs, the annual growth survey, and this despite the fact that according to the Commission's own guidelines, they may well be subject to impact assessment. So there has been the socialization of the semester, but as I've already hinted at, in my opinion, it's only made the system evolve marginally. The core of the decision-making process, the core of the methodology hasn't moved an inch. And a final important element is that strong processual guarantees are still lacking under standard economic governance. More specifically, what do I have in mind? It's the fact that those actors that would be the most likely to bring fundamental rights consideration to the debate are actually sidelined or kept as marginally involved as possible. I have in mind, of course, the parliaments, the European parliaments, but also the national parliaments, and I also have in mind, of course, social partners and civil society. Again, there has been some marginal evolutions with the socialization of the semester, but nothing groundbreaking, I'm afraid. So the assessment that we make is one of a lasting imbalance between the economic on the one hand and the social on the other hand. The main reason for this is that fundamental rights consideration are very lowly internalized by decision makers, and they fail so far to meaningfully guide and constrain economic and fiscal policy making at the level of the Eurozone. And this substantive neglect is compounded by procedural deficiencies. And this is all the more worrying that in a post-crisis era, economic governance has a globalizing tendency. EMU has very much become a meta-policy field through which all kinds of coordination are taking place in the field of economic policy, but also in the field of fiscal policy, of employment policy, of social policy. It is truly the most central matrix through which policy coordination is being conducted. So there's a real absorption that took place after the crisis, the result of which being that we have one core coordination process through which everything is taking place. So there's a clear discrepancy between, on the one hand, the nature of economic governance, its core fixed features in a post-crisis era, and its constitutional credentials and the constitutional guarantees that it offers. So one has evolved substantially, the other has not, and there's a clear misalignment. So the matter is primarily an institutional one. It's the political institution of the EU, starting with the Commission and the Council, that are to blame for this state of affairs. Of course, this imbalance could have been corrected by external reviewers. We've seen this happening. Course and other external reviewers stepping in order to precipitate administrative change, in order to precipitate needed transformations. But this did not really occur at EU level. So Claire has described the evolution of the ECJ's case law, and clearly the court has, in a first step, rather tended to consolidate this imbalance between the social and the economic, and then it has started to challenge it, but only marginally, with rulings such as Ledra, such as Florescu, such as the Portuguese judge's ruling. The same can be said about the Fundamental Rights Agency. The EU has an agency that is tasked with the preservation of fundamental rights across all kinds of policy fields in which the EU is active. So clearly the agency would have had the resources, would have had the institutional position to trigger the kind of transformation that should have occurred. But this did not happen, for the main reason that, as you know, the agency is not the master of its mandate, it's not the master of its mission, but it's tasked to investigate certain policy fields that are identified by the Council and the Commission. And of course, what a surprise, the agency was never tasked to look into the fundamental rights implication and the fundamental rights impact of economic governance. So secondly, before moving to delineating a potential way forward, I'd like to come back to this issue of the relevance of the Union fundamental rights regime to this whole policy field that is the economic governance of the Eurozone. And in that regard, we need to make a distinction between EU institutions and between the member states. When it comes to EU institutions, it's crystal clear since LEDRA, EU institutions are bound by the Charter in any circumstances, even when acting outside the scope of Euro. So this has been clearly stated in LEDRA. There was space for doubt before LEDRA, but now it's clearly settled. And this is also confirmed in secondary legislation. Six-pack regulations, two-pack regulations also refer to fundamental rights and to certain specific Charter provision. It becomes much more trickier when we look at the member states. So what about the rest? What about member states implementing country-specific recommendations? What about member states implementing memorandum of understanding? Are they acting in the field of EU law? Are they acting in the scope of application of the Charter? Here again, I distinguish between extreme and standard economic governance. When it comes to extreme economic governance, there has been much uncertainty, but it's getting clearer and clearer that the Charter may well be applicable. So the court clearly said so in Florescu. You have remaining gray areas, but the picture is clearing up, and it looks like the court is going for applicability. When it comes to standard economic governance, I am of the opinion that crucial concepts such as bindingness, legal effects, are concepts that need to be revisited. And this classic distinction between soft law and hard law maybe is not entirely relevant to this policy field. So, in my opinion, we may well find situations where member states acting in the field of standard economic governance, member states implementing recommendations that they are addressed in the framework of an excessive deficit procedure, member states implementing a country-specific recommendation may be deemed as acting in the field of EU law, as implementing EU law. Again, it will depend on a case-by-case analysis. It will depend on the strength of the connection between the EU policy prescription and the national measure. But again, the Florescu ruling is showing that we may face a situation where that link is sufficiently strong to find the member states as implementing EU law. And there's actually a recent ruling from the Court of Justice dealing with a Spanish case, so a ruling from last February, that seems to confirm this. It relates to a Spanish budgetary law implementing a wide set of budgetary cuts and salary cuts in the public sector. Certain of these cuts were criticized as being potentially discriminatory between different categories of civil servants. It's judges. It's quite funny how it's always about judges. Someone should look into this. But it's again potential discrimination between categories of judges. Ultimately, the Court of Justice found that there was no discrimination. But the key takeaway is the fact that the court deemed the Charter and the Equality Directive applicable. The Spanish authorities were implementing recommendations that they had been addressed in the framework of their excessive deficit procedure. So they were passing a budgetary law and passing salary cuts, and the court considered that the directive was applicable and that the relevant Charter provision could well be deemed applicable as well. So that's potentially something new in EU law. For the first time in the field of standard economic governance, potentially the Court of Justice finding the Charter applicable and finding the member states implementing EU law. All right, and finally, I want to devote my last set of remarks to the way forward. How can we correct this imbalance that I've been talking of during the first part of my presentation? So how can we correct this structural discrepancy between what economic governance is today on the one hand and the guarantees that it offers in terms of fundamental rights protection? So I see two potential priorities. The first one is that we should foster the internalization of fundamental rights consideration by the actual decision makers. And at the EU level, that is the Commission and the Council. So we should force the integration of fundamental rights into the design of economic and fiscal policy making in Europe. So the idea would be to use fundamental rights as prioritization tools, so tools that can efficiently shape policy design and both agenda setting and the definition of the policy mix. So this does not come out of nowhere. The Human Rights Council had been advocating for this kind of stuff. The Committee on Economic, Social and Cultural Rights has been repeating this time and time again, and the European Committee for Social Rights has been making the same kinds of recommendations as well. So how exactly can we do this? I think that the main important element is that the institutional methodologies should incorporate proper rights-based indicators that directly relate to the normative components, to the normative content of the rights. So since the socialization of economic governance, we have social indicators, but we still lack rights-based indicators that could potentially open up the discourse and force political institutions to consider fundamental rights impact of the measures they are taking. The second element is that social impact assessment, well, should be generalized in all prongs of economic governance. It's been emerging for extreme economic governance. We saw it with the third Greek bailout, but I see no reason why this should not occur for standard economic governance as well. A third element is, of course, enhancing the inclusiveness and the transparency of economic and fiscal decision-making that is meaningfully involving parliaments and social partners. And finally, there should be a proper duty of care on the part of EU institutions. There should be clear duties to spell out the reasoning that they followed, to clearly spell out the rationale that they favored, how they have designed the policy mix, what alternatives they consider, and why ultimately they decided to go for the policy mix that they've ultimately favored. So again, it's a question of institutional practice. It is for the EU institution to precipitate these changes. But again, courts can play a role as catalysts to precipitate these institutional changes. And this actually occurred recently in a ruling from the German Constitutional Court from last December. Quite an interesting ruling, which shows precisely how courts can precipitate institutional change when it comes to economic governance, when it comes to fiscal consolidation. So very briefly, the circumstances are quite similar to the ones of the Spanish case I've evoked a few minutes earlier. It's about a consolidation scheme implemented by the land of Baden-Württemberg, and again, a consolidation scheme implementing a wide set of salary cuts in the public sector. Similar circumstances, a category of judge deemed themselves discriminated against, brought a case, this time at the national level, before the German Constitutional Court, claiming that this whole scheme was discriminatory. And the Constitutional Court made a few interesting pronouncements. First of all, it said that the burden associated with fiscal consolidation should be fairly distributed across society. That means within specific professional groups. Here at stake was the public sector group, and the court found that there was a discrimination and that younger judges had been discriminated against because the salary cuts that they had to undergo were much more substantial than the one elder judge had to go through. So equality within specific professional group, but also equality across the board, across society, between different professional groups. So this, in this case, between the public sector and the private sector. So that's a first interesting pronouncement. The second one is that the court derived from the German constitution procedural safeguards in order to guarantee that fundamental rights would be protected in the framework of economic and fiscal policy making. It basically forced political institutions to structure and to rationalize the way they think about fiscal policy making, the way they think about economic policy making. More importantly, it also forced political institutions to reflect in a diverse manner, to consider alternative paths, to consider alternative schemes. So it forced political institutions to open up the discourse that grounds economic and fiscal policy making. So quite an interesting ruling. It may sound familiar because it actually does. It's quite similar to what the Portuguese Constitutional Court did between 2010 and 2014, but in my view, it's probably even more noticeable, not only because it comes in a post-crisis situation, so where the crisis is less in a fast burning phase, but also because it comes from a country which has traditionally been perceived as the staunchest promoter of consolidation and of austerity, and also because it comes from a constitutional court that is highly regarded across Europe. So quite an interesting ruling showing how courts can act as catalysts and precipitate institutional change. And of course, to the second priority that I identified, and I'll be very quick here because it's very similar to what has been said, for example, by Dagmar. But I think that the first priority that I identify has its own limits. It very much relies on a very defensive understanding of fundamental rights. It's more about protection than actual fulfillment. And also it doesn't really challenge the macroeconomic essence of policy coordination today. So this first priority needs to be complemented by another approach, which is based on a more positive understanding of fundamental rights commanding active lawmaking, commanding actual realization. Of course, that was the spirit of the pillar, that was the promise made by the pillar. So far, not really a promise that was kept, but I think that there's also a need to keep on militating for positive lawmaking in the field of social policy, and with proposals such as minimum wage or collective bargaining or a European unemployment scheme. So there's a need for active lawmaking at EU level. So I leave it to that. Many thanks for your attention.
You have it? Yeah. Is it here?
In my email.
Oh. So the turn is now to Catherine Jacqueson from the University of Copenhagen. and she's going to talk about the free movement and social protection, our relationship in crisis. So, your turn.
Thank you very much, Marcela, and thank you very much for inviting me, especially to Maribel, that I know from the BU Citizen project some years ago now. Thanks for Marcelo also to take really good care of me and the others, and to all of you for being here now that we are reaching late afternoon and the sun is still shining, and I'm the last one talking, and I'm a free movement lawyer, so I've been asked especially to assess whether free movement can be an avenue for social protection, or maybe not. And I've decided to view this as a relationship, a couple relationship, an old couple relationship, and to see whether, I can say that my main point here today is that free movement and social protection go hand in hand, that they are very essential to, they're fundamental and essential to the EU, but that this relationship is challenged, and the challenge needs to be addressed. So that's the main point. And I will proceed by looking at 3 issues. First, explaining how this is has a strong relationship with a strong foundations, and then go briefly to the challenges and also look at how this could be improved, this relationship in crisis. A strong relationship, how is that? This is because that since the beginning of the community in 1957, the choice had been taken to grant equal treatment for EU citizens when they settle in another member state. So this was especially true for economically active, and this is from day one. From day one, you move, you work, and you're self-employed, then you get access to the welfare community of the host states, thereby enjoying nearly full protection as a national of the state. So you could say that here there's no competition possible, for example, in terms of salary or others. You're part of the community, you are submit to the rules, but you also benefit from it. And this equal treatment perspective and access to the welfare state of the host member state was also given to other, I think that's maybe an old PowerPoint that is here. Okay, anyway. Then, yeah, maybe because I'm sorry that's, it's here? Yeah, because I've changed it, and I discovered some things that were not completely, no, maybe. Which one is it? Then I think I'll go to my PowerPoint, to my, yeah. This one, is that yesterday, yeah. Sorry for that. I think this is the one. Yeah. Okay. But then you don't have with the animations? Sorry.
I need to.
Okay, you can't see that. That's a bit annoying because it's I like the thing with the animation so that you don't get all the information at once, but okay, let's do like how it is here. So normally there should be a little activation saying that now that the free movement has been given to all union citizens, and when they lawfully residing in another member state, the same principle of access to the welfare community is also a right that they have. So you can say that free movement is very much connected to access to to contribute, but also to access to the welfare state, and very much based on a concept of EU social citizenship, at least for those who belong to the community. And this has this principle of free movement and social protection and equal treatment has been put recently into perspective, or how important it is in the context of Brexit. For example, where a lot of EU citizens were considering living and residing in the UK, were considering maybe to leave the UK because they might not necessarily be granted equal treatment any longer. The government might have some leeway in this respect, and this really is an argument saying that equal treatment is important to the union citizen and should therefore be cherished. We also see that when we compare to the EU measures which have been adopted concerning third country citizens, that there is also this important principle that they should be treated equally, but it's not as encompassing, it's more limited, and it's also more conditional. So, getting back to my point here, that free movement and social protection are a strong relationship through the principle of equal treatment. So you could say, okay, this is maybe just a honeymoon relationship if we go back to this couple relationship between free movement and social protection. But there are two weak points which are inherent, you could say, in the community or the union, how it's built. The first one is that this right to equal treatment and access to the welfare state is an EU right, but who is paying? It's not the EU. It's the member states, and it's especially, in most cases, it's the host state, which has to pay for citizens which might not have contributed that much, for example, to the public purse. So that's one, you could say, one weakness. The other weakness is that equal treatment has been balanced in favor of the free movement of services when we considered posted workers. Posted workers, those who are working temporarily in one member state and then go back to their employer in another one, are not, in principle, a part of the community of the host state, and therefore are not protected against unequal treatment. So here we have the economic paradigm of the community very clearly, very salient here. In this case, that it's the services which are winning and not the posted workers or the workers generally, you could say. So I will argue that those two points are the inherent weaknesses of the relationship. And this weaknesses or this tension about posted work and social dumping, and also that it's an EU right, but it's the member states which pay, have been further, how could I say, developed or have been further salient following the enlargement of the EU to the Central European member states from 2004. Because what? Because the differences in wealth and in social protection have dramatically increased. So making, of course, maybe the older member state more attractive to the new member states. And also what we see maybe for the first time is that people are massively using their right to free movement. So this is maybe also some things that make it also more problematic on the ground, in the reality. So the tensions have been further exacerbated with the enlargement to the new member states. And this has created tensions. This has created tensions as EU citizens are, especially since 2004, in some respects seen as a burden on the welfare state. And this has given some political discontent. And this we have seen, for example, with the UK and all this debate leading up to Brexit and the settlement agreement and so on. And we have also seen that free movement is a threat to social cohesion. And this maybe also leads to the argument of solidarity here. And if we reason in legal terms, you could say that it has also created some problems in defining who is in of the community and needs protection and who is out. And this is especially true in respect of the broad concept of worker. Where does it, the court has interpreted very broadly, also because, as also Dagmar was saying, that one of the aim of the community is to improve the life of the people. And one way of improving your life is to maybe work somewhere, maybe not so many hours, maybe for so not much money, but still it's an improvement for you. And in this respect, therefore, the court has concluded that there needs to be a broad concept of worker, also encompassing people who are maybe working very little and maybe need public support. And because of the principle of equal treatment, then you can have access to the welfare state, to some welfare help. Some help from the welfare state. This has been also a source of tension and has been interpreted very differently in the member states. So some have respected more than others the case law on of the courts on a case-by-case basis. Another issue is the tricky case of job seekers, because they are protected by EU law, but not so much as workers. So their access to social protection is not as broad as a normal worker. They're a little bit, I will call the in-between. So this is a clear case of a little bit It's dismantling between, on the one hand, free movement. They have a right to free movement, but maybe not to social protection. Maybe a bit equal treatment in accessing jobs and so on, right to reside, but not much more than that. And this will have the Court of Justice word for restricting a bit the social protection of the job seekers after having opening it. And then we have here a clear dismantling, you can see, between the right to free movement and the right to access to the welfare state for those who are inactive and who become a burden. And in principle, the court, we could say for once, was very clear in its message, saying that those who are not lawfully residing in the member state should not have access to the welfare state. But still, it's very difficult to figure out when are you lawful residents and when are you not. So we have two main challenges, I will say, that the EU cannot afford to ignore. The first one is what to do with the left out, what to do with those who are EU citizens, are moving, but maybe at some point are not lawfully residents and therefore are cut from access to help, from public health, what to do with them. And I think another big challenge, which is now addressed, is the issue of social dumping and trying to outlaw this phenomenon is one, I think, one of the necessary move that the EU has to take to go in a more social direction. And both issues, both this what to do with the left out and outlawing social dumping, revolve around two concerns, but specifically social cohesion problem that I have talked about. And if we look at a more individual level, the protection of fundamental rights or individual rights. So let's look very briefly now at two avenues for improving this, for improving the challenges. Let's look whether the equality road is a road which can be taken, and the other one is the human rights road. And both avenues, you could say, imply discussion of who should act and which level, which institution, and how to act by hard law, soft law, that we have discussed before. If we look at the equality road, especially the sociologists have argued that one way to include the left out is to grant them equality, and have relied on the US model in this respect, where the Supreme Court of America has been quite proactive and has protected the right of equal treatment and for US citizens moving from one state to another. But I think that the US way is an attractive way, but for me it's more a dead end in the EU context because of the Dano case, where the court has, you can say, taken a decision going the other way around. There's only the lawful who can have an equal treatment, and that I think will be difficult to reverse. Another thing is that there is a conditionality to free movement in the EU, and it's in the treaty, and it's of course in the Residence Directive or the Citizenship Directive. It's only those who are working or those who have sufficient means not to become a burden. And I think also that is a no-go for extending equality to those who are not lawfully residing in another member state. And also there will be the issue of social cohesion that I go back to, that they might create problems in the host state by saying, okay, those who are just coming here and not really contributing to the state might have access to public support. So this is also, I think, an issue which, a concern which makes this road not an attractive one. Then sticking to the equality avenue for improving the relationship between free movement and social protection is to outlaw social dumping. And here, as those intervening this morning have made clear, that it is now up, especially up to the EU legislator to act, and they have acted. And again, here Macron was one who was very much in favor of the revision, and who pushed the revision of the directive on posting of workers. And what I find interesting, that's many interesting things in it, but one is that we've gone to minimum pay, from minimum pay to equal pay. So this principle of equal treatment takes more place in a free movement context, and therefore also ensure more social cohesion. And so the EU legislature is here revisiting the balance between services and the protection of posted workers. And you're also saying that it were a bit of a tango tango dance, because the court itself had already announced that minimum protection could be interpreted more extensively in the famous Electro-Budauer case, and yes, especially in this one. So there is happening a rebalancing of the internal market from within, you could say, from saying, okay, now we have to reassess the relationship between free movement on one hand and protection of workers on the other hand. And the protection of workers is, at least in theory, I think on the ground would be much more difficult, but at least in theory it's an important political message going in the direction of a more social Europe, and we also see it in recital 16, especially of the posted directive, where it says that in a truly integrated and competitive internal market, we do not compete on salaries. That's my translation, say we compete on other parameters, but not on salaries. So this is maybe the hope message, saying that the internal market can be internally rebalanced towards more social protection. This is one evidence here. If we turn to, and that would be my last point, if we turn to another avenue of trying to rebalancing or trying to give some kind of couple therapy, you could say, to this relationship between free movement and social protection, there's the human rights dimension. And people who are moving but who are not part of the welfare community of the whole state might get some protection through the human rights avenue. And here we can look at two ways, as we also saw this morning. There's the judicial way and the EU legislator way. Is there any hope here to, again, looking at the European Court of Justice and saying, can you help in case, help those people who are moving, who are maybe not lawfully resident, maybe they're not unlawful neither, so they're a little bit also in between. Can you at least give them some kind of minimum basic help, human rights protection, for example, access to shelter or to food or to... We're not talking about cash, we're not talking about money, which is something that, which I just discussed. It's not, I think, an avenue that it's not a go for now, at least. But can you at least protect them, because the EU is based on fundamental rights? And can the court do that? And the court is, you could say it's, there was some hope from the beginning, especially in the Constantinides case, where the Advocate General Jacqueson was saying that when you move, then you are automatically protected as a European citizen, and you have some rights which are connected and shall be protected. And the court has also been quite generous in some cases, and saying maybe you don't have a right to stay, but you cannot be removed without the member state making sure that your fundamental rights are not infringed. I'm here referring to the Akrish case, which is an interesting case in going for a broad interpretation of the application of the Charter for or human rights for people who may not have a right to stay but can have at least some minimum protection. The Dano case is, of course, the clearest case, saying that when you are not lawfully resident, you are not it will be very difficult to activate your fundamental rights. And the court used a very strange argumentation, which is one based very much on competence. You are social assistance, social help is something which is the competence of the national states. The EU has no power to harmonize the area, therefore they are not acting, they are not implementing the EU law, and the Charter is therefore not applicable. So this was a bit disappointing, you will say, in the light of social protection and fundamental rights that the court has taken that way. It has been more inclusive in cases on family unification based on Article 20, on the fact of being a citizen of the EU. And here I'm referring to the Chavez-Vilches case, which is an interesting one because the court is very much keen to refer nearly immediately before deciding whether EU law is applicable or not, to say, okay, you have to figure out if there's a breach of Article 20, whether this will breach the fundamental rights. So citizenship, the fact of being a citizen and fundamental rights work very much closely together in this type of cases. So maybe this could be an avenue to say, to push the court in the direction of saying that when EU citizens are moving, that there is a core of basic fundamental rights which should be respected by the host state, whatever the situation, and therefore some provisions of the Charter might be applicable. I think that it's not an easy case, and it will necessitate good lawyers to push the court in this direction, but I think it's a necessary one. Then another avenue of protecting those fundamental rights of free movers is, of course, to go through EU legislation. And here there could be EU minimum standards which could be applicable. I'm especially thinking about that. That could be an agreement reached by the member state in this respect, in adopting minimum standard. And also another issue that we discussed beforehand is this morning and this afternoon is the potential maybe of the pillar of social rights here and the tools which are nevertheless there, such as the social scoreboard, which could be interesting here in pushing the member state to have structures which could protect free movers who are in a legal limbo, you could say. So now I come to my conclusion on this relationship in crisis. I will say that it's a relationship in crisis, but it's a strong relationship, and it's one you could argue it's for better and for worse. It's one of at the foundation of the EU, and one way of going through is to start maybe to renew the vows, you could say, by addressing the weak points in an increased diverse Europe. That's what we also talked about this morning and this afternoon, is that there is an increased diversity in Europe, and that it's a very disunited Europe in diversity, and maybe redirected to a reunited Europe in still diversity, because we won't escape that. And again, just to sum up, is that the Posting Worker Directive is, even though it's not groundbreaking, but it's a little push in the direction of rebalancing the market from within, which might also spill over to other areas. And another thing that I would like to go more into, to do more research on, is the potential of the social pillar as an additional, powerful addition to social Europe, and the protection especially of the free movers who are in between. And to conclude is that there is a role for both the legislator and the court, and that I will say in this context of free movement might be again, a powerful couple and more working together than working against, as we have seen maybe in the context of the EMU. So that's my conclusion. Thank you for your attention.
Thank you very much, Catherine, for this interesting approach of social rights protection. We have plenty of time to start for discussion, so I would like to open the discussion time now.
I have a few questions for Catherine and for Paul. The first question for Catherine is, I fully agree with you. I mean, I see the change in the Posted Workers Directive. On the other hand, I think this also raised a lot of controversy with the yellow card and notably national governments, from Eastern Europe being against it. So I'm wondering what you think, I mean, whether there is really potential that it will go further, because there was a very strong willingness from, the French and the Germans and I think the Belgians to push for the reform. But I'm wondering if, they will be ready to do this rebalancing exercise in other areas when we know that in Eastern Europe there is such a strong opposition in this sense. And for Paul, the question, I mean, you were, I think, quite critical of the Commission and the Council and how they don't take social rights into account, but I also think if you consider the European Parliament's role, that it's not helping either. And for instance, there was a discussion as to whether this interparliamentary cooperation meeting that is taking place in February should be moved to June, so that they can really discuss CSRs and other recommendations at that point. And it is my understanding that the EP was not ready to do that. So, I think I fully agree with you that it's a minor partner in this regard, but I also think it's not taking sufficient advantage of the instruments that it has or that it could have for national parliaments. And I would dare to say that also national parliaments are not taking full advantage of the instruments they have. So if you look at the implementation of the European semester, in most of them, they haven't adopted any specific instrument for their participation in the European semester. So, I think it's also self-inflicted, so to say. And an overall remark, and that also links back to what we were discussing this morning, is I was just checking now the compliance of the CSRs, and it's approximately 30%. So I'm wondering, okay, and now I'm being a bit controversial. Yeah, but that's not a lot. So I'm wondering, I mean, are we not now discussing something that is, in the end, not so important?
Oh.
Maribel? Yeah, that's better, yeah. Okay, but maybe I didn't quite get everything you said, I have to say, so maybe my question is silly. But you were discussing the Spanish mortgage cases as an example of how you have, your title is Social Rights Protection Through Economic Rights. Yeah. So could you specify a bit more why you think this is through economic rights? Because I found this was straightforward social rights. The legislation is consumer protection, which somehow is related to social rights. So that's what I didn't quite get. And maybe there's a very interesting argument in there which eluded me. Yeah, so yeah, that is more or less. I think you made the same point in relation to the collective redundancy case. And again, for me, this is social rights legislation. Yeah, so, but maybe I'm wrong there.
Thank you very much for all the presentations. I have, two questions related to Paul, especially. Your first priority was internationalization of, at the EU level, of fundamental rights. But I want to question you if already
there is not such internationalization at the constitutional level, especially of economic and social rights. It's not a too demanding question for the EU that you request this internationalization at the EU economic governance in that way. So how you deal with this difference in that way? The Spanish case is quite an example in which economic and social rights are not very well integrated or are not very well protected from the constitutional perspective in that way. So requesting this internationalization that you said at the EU level, economic governance, maybe is too much for the EU. And related to that, and I was wondering also your answer about, it seems that you bolster, or you want to bolster this internationalization through a judicial review from the ECJ that is quite procedural in nature, if I understood you well in that way, no, it seems. But especially in relation to Gaubelier or Ways, in relation to the ECB cases, also in that way applying a little bit the economic governance, or are in the satellite of the economic governance, a lot of the literature, especially the judicial, or especially the lawyer's perspective, this procedural stand is quite criticized as a very, very, very differential in that way. So really, you can bolster this internationalization through a procedural review. It's quite suitable, this procedural review, for this internationalization, or maybe you need more a substantive judicial review approach in that way. Maybe I disagree with this literature, and maybe I think that the Gaubelier test and the Ways test is quite substantive in my point of view, but maybe I wonder if you want to say something about this, if you prefer this substantive, more procedural. I can understand that fits well your point, the procedural review, because you want that the legislature at the EU level and the economic governance, all the institutions at the EU, they want to discuss fundamental rights there. So if the ECJ is bolstering this procedural review, so is requesting that you take all the alternatives into account and so on, as you said, no? But maybe this is enough, or it's very differential in the way this standard of review, and especially from the ECB cases, a lot of people is saying that, no, in that way, that this is not enough. And very related to that as well, that I am wondering also because it was very interesting, your presentation, so for me it's very challenging in that way. If you want to bolster this interiorization at the EU economic governance, maybe do you prefer more a national approach in that way through the preliminary reference, or the action for annulment in that way is a good procedure in order to bolster the ECJ intervention? Because the EU economic governance and all the instruments that come from the EU economic governance, it's very difficult from the action of annulment, the legitimation of citizens, especially to present this action for annulment, because they are more, you don't have this special individual interest in that way, so it's very difficult. So you need the national courts then, like the Portuguese cases and so on, in order to bolster this internationalization. And then it's quite tricky for you in that way, no? Because you want internationalization at the EU level, but it seems that you need the preliminary reference and bolstering cases from the national level. So maybe this is quite difficult, because at the end, moving the ECJ at the EU level with the action of annulment seems difficult in the aftermath, no? in the context of the EU economic governance, because of this lack of a specific and individual interest of the standing doctrine of the ECJ in that way. And well, relating to that with Catherine in that way, that it seems that from the free movement, it seems easier in that way to do this, no? And not with EU economic governance as well, but because the primary reference is much easier in that way in the free movement, because there are much more individual interests in that way to make litigation possible. It seems that the ECJ it's in a better position from the free movement in that way, with coordination with national judges in that way, than the EU economic governance. So it seems that fundamental rights can be improved better from the free movement perspective than from the EU economic governance perspective in that way. And I don't know if you want to relate this interrelationship, Paul and Catherine. Okay, thank you.
Any other question? Okay.
Maybe I can take your last question on the relationship on the European Court of Justice and in protecting, being in a better standpoint in protecting fundamental rights in a free movement context than in the EU. But you could say yes, that's true, that it might be an easier one, but at least it is also one where the court has pulled the brake. You could say that it has been a really important actor in promoting the rights of free movement and promoting the social protection of those who are using their rights. And here we have, you could even say that it's one of the creators of the social rights, at least for those who are inactive union citizens, not the workers and the self-employed, where it has been an essential actor, but it has also been one which has, despite this big taking position, has pulled the brake and say we can't go, we have to take back a bit of the protection that we have given, and cut a bit the protection by being stricter in saying who is in, those who are lawful and those who are contributing, and therefore who has protection both in social protection but also human right protection, and who are outside and thus cannot get help, neither from cannot get help and nor from the court, and what I think is mostly problematic, even cannot get the basic human right protection. So in this sense, you could say, yeah, maybe it should be it should be an easier relationship and the court should be more at ease, but it's not really what has been happening in the last period. At least when you're considering those who might be a burden on the welfare state, and all this debate on the welfare tourism, where the court has read the newspapers, you can say, and has listened and has taken back what it has given. So that's one point. And going to your question on the fight for outlawing social dumping and increasing equality of posted workers, whether that will be a step forward. Yes, I think it's a difficult one because of this conflict between West and East, and also because of this issue of subsidiarity and so on. But it has succeeded, you could say, at least for this time. So it needs to strong. Yeah, it's a bit difficult to say why did it succeed and why didn't it succeed before. And Macron might be a part of the answer, but not totally. But it will be very interesting to see what will happen also in the Court of Justice, because this directive has been challenged by Poland and Hungary, and saying that here it's amounting to protectionism and it's breaching the free movement of services, and the legal basis is the free movement of services. And this is a restriction on the free movement of services to grant full equality, and so it's really a very delicate issue and a very complicated issue, and I think that the court will follow the legislator, but because also in this light of social Europe and Article 3 and Article 9 of the treaty. But yes, it's a bit it's an issue where you can't say too much with certainty, I would say.
Okay. Okay, what was the point? I think that, okay, the point is twofold. On the one hand, it has to do with the reasoning of the court, where it it strengthens, what is the focus? So I mean, if you took the cases of consumer protection, yes, you can say social litigation or economic litigation both, but it's not the same if you focus on consumer protection or you focus right to housing. Consumer protection is why I think it's an economic right, but right to housing is a social right. I mean, whereas in consumer protection, the core aims at protecting equal information, judicial guarantees, a certain asymmetry at the beginning of the relationship. Right to housing is to help the ones in need. It has more to do with the transfer of between people who has and people who hasn't, what we could consider basic goods. And I think that the Court of Justice relies on consumer protection in many cases, first because of the principle of conferral, probably. It can feel comfortable with consumer protection. It has secondary law, it's a well-settled case law, but it's limited. And for me, it's quite interesting that it quotes the importance of the dwelling, the importance of the home, but if we look at in which cases the court has explicitly quoted right to housing, you had Smart Capital, Article 7, that was an extrajudicial informant, which is similar to Article 8 of the Convention, so it was a quite clear case. And then you have a city case that it went further, but there, again, you have a directive. Or Canberra case, again, was a discrimination case, and it could rely on. So what I mean is that the court relied on economic rights, this case consumer protection, to try to reach a social right that otherwise could fall outside of this scope. I don't know if I make myself clear. So that's why I say. And the freedom to conduct the business, it's slightly different because it quotes directives on social rights. But for instance, if you go to Pujante Rivera case, instead of going to the point that is that what the Spanish legislature was trying to do was that it was easier to make a collective redundancy because in many cases it wouldn't be declared as such. That was actually the point. That was what the Spanish legislator was looking for, since making these essential changes in the contract were not. But the Court of Justice, instead of going to the articles in the Charter that protect workers in collective redundancies, didn't go to 27, did they go to 30, went to competitiveness within the EU. That's what I mean. I mean, this is an indirect way. The court might feel safe. It's like in terms that this is a well-settled case law. I also question when I deal with this. I have a case law through the years on the competitive economies, and there should be fair conditions among member states. And instead of going to the Charter and develop the social rights, that could do it, actually, because there's a directive. But it tries to shy away from deciding on the social issue, but to a certain extent to protect it. That was perhaps a very dumb argument, but that was the
So maybe to first come to Diane's point on first of all on the parliaments. Well, I mean, I agree with you. The reality is much more contrasted than one may think. I think, for example, the European Parliament has had its moments in 2014, 2015, with the inquiry into the role of the Troika. Currently, it's maybe less of a fighter on those questions. And the same goes for national parliaments. I mean, you are the parliament person, so I won't contradict you on that. When it comes to the implementation weights of CSR and whether we should actually care, you read that sometimes. You have some authors saying, well, actually these changes, it's mere cosmetics, it's as inefficient as it used to be. Well, that's certainly not my opinion. First of all, when it comes to the metrics, it's highly debatable. You have a lot of different statistics. Whether you read the Commission statistics or other statistics, you don't have the same figure. And also, I think it's really difficult to measure the actual implementation of CSRs. Because most generally, they are not fully implemented, because what is being recommended is, in a way, implemented, but with a lot of variations, a lot of differences with what the Commission in the first place suggested. But I think that if you look at the wider picture, so that is the semester with the CSRs, but also the harder mechanisms under the MIP, under the Stability and Growth Pact, you cannot deny that there is a general socio-economic pattern that is being exported from the supranational level to various member states, and that counts for bailed-out countries, but also other countries. So there's my view, in my opinion, there's definitely something going on, and those issues are definitely worth looking into. But of course, implementation is an issue. Of course, the EU institutions are aware of that, and they are currently discussing proposals in order to enhance efficiency and implementation. So all these new budgetary instruments that are being tabled, they will all be conditioned on compliance with the CSRs. So that's a new version of conditionality that will probably become true in a few months. So of course it's an issue, and of course the EU institutions are working towards doing better in that regard. When it comes to the question of the review by the Court of Justice, well, that's always a difficult question. How do you balance meaningful judicial review on the one hand and executive discretion on the other? Indeed, what I have in mind and what the German Constitutional Court did is indeed very much a process-oriented review. And I believe that if you do this in a sufficiently credible manner, it can actually work, and that ruling is an example. Of course, you have all the criticism regarding process-oriented review and the ECB in the Goweiler and in the Vice judgments. I guess it really depends how you carry out this kind of review, where you put the cursor, whether you do it in a highly loose and differential manner, then of course it's probably not going to be efficient. It's probably not going to be meaningful enough. But then I think there's also a strong argument to be made in favor of respecting political institution discretion on those questions, because fiscal policy, economic policy, those are fundamentally political policy fields where representative institutions ought also to be recognized a fair level of discretion. When it comes to the question of whether it's actually feasible to internalize fundamental rights considerations at the EU level, I believe it is. If we are not too ambitious, I believe it truly is. I think that the EU is administratively equipped to do this. It's already doing it in a lot of legislative processes. So if we clearly identify circumstances where this should be done for economic governance as well, I believe it's doable. And finally, on your question on how triggering judicial review, preliminary ruling, or action for annulment, of course, currently, under the current case law of the ECJ, which sticks to the Plowman formula, it's absolutely unimaginable that private applicants will successfully launch an action for annulment. It's simply not envisageable. But again, I believe that the court's case law could also evolve in that regard, and also I believe that, and that comes back to Diane's point, I believe that privileged applicants could also have an important role in potentially challenging outrageous EU acts in the field of economic governance. But of course, it's a major difficulty, and claiming that private applicants could reach the docket under the current circumstances is a far stretch, definitely.
So thanks very much to everyone. I always enjoy conferences much more after I've finished my own paper. And so I've got a lot of food for thought from all the papers. But I've just got 3 small comments or questions. So all the Spanish housing stuff is incredibly interesting, so I want to find out a lot more about it. But my question, though, which would be connecting Maribel's paper with Paul's, and connecting indeed the Spanish cases, the Aziz case or the cases Maribel discussed, and the Escribano, the case that you discussed, the fiscal consolidation discrimination case. So in both cases, you might say, wow, isn't this a big contrast with the kind of arguments I was making this morning? So, you know, that the court had never condemned a sovereign debt measure. And on the other hand, Paul, you use it to suggest that soft-ish norms under the EDP may be more challengeable or harder than we think. But I wonder, is there something much more straightforward going on here, which is not bad, but not unsurprising, but again, underlines how the EU Charter is maybe not the best avenue to go for those wanting to challenge things in the EU law, because these cases, for me, are both easily explained, and the Hogan case as well, that you also mentioned, Maribel, because they concern a very standard practice by the Court of Justice. No tricky questions, is this EU law, not EU law, is it law, has the EU breached fundamental rights? No, we're just applying our social acquis to national law. We are very comfortable, we are very happy doing it, we have absolutely no problem. And indeed, I think that would have been a better strategic way to challenge the measures people did not like in the MOUs, because many of them did breach the acquis as well. So there was a bad strategic error, but nonetheless, does this not explain Aziz and the Escribano case? Then the second little point is just about, so Paul, you said that the EU had not internalized fundamental rights into standard economic governance, if I heard you right. But what about the two-pack regulation on macroeconomic adjustment programs, which cites, you know, Article 3, Article 9 of the TFEU, and the preamble says we're going to comply with Article 28 of the EU Charter. We are going to respect Article 152 on social partner dialogue. So I just wondered, how does that source, of course, you know, we can say that source came too late and none of the programme measures challenged where the MAP was not enforced then. But is that not an internalisation of fundamental rights into economic governance? So anyway, just a question. Then I wanted to play a bit devil's advocate with Catherine's paper, which I find very interesting, but I think this whole free movement area is becoming very, very complicated in lots of really interesting ways. So I think also the history of free movement is being rewritten. So now people write things saying there were always emergency breaks and there were always things like that, a big article in the Common Market Law Review. So we just need, this has always been part of the history of free movement and it will be again. So that's a very different history from the equal treatment day one. But more specifically, I wondered about the balance that you were presenting in your paper. So I just wanted to get you to tell us more about it by challenging it a little bit. So on the one hand, do you think the balance struck in the revised Posting of Workers Directive is a good one? Is there nothing we could say is problematic about it? Because one thing is saying equality for posted workers, another is a new legislative instrument which essentially discourages cross-border posting from taking place. So is it as golden and perfect as perhaps you, with very little time available, presented it? And on the other hand, I wondered a little bit, I think one of the things about free movement of work or free movement in EU law is that the line between mobility and migration is becoming less clear, let's say. Even in terms of how people conceive it. You used to think someone who was exercising EU mobility was very different from a third country national. And the way you presented how to resolve the Dano argument, so let's ask for fundamental rights for economically inactive people who are in Germany or whatever, it seemed to me it got a little bit close to crossing that line, because if you're saying you've got to give them some basic rights while they're there, I think it's quite interesting to look at the distinction made between, say, asylum seekers. So my question would be, what menu of rights? Because asylum seekers are given a minimum set of rights for asylum seekers, so education, material conditions, the right to look for work, and then 9 months after making the application. But then there's another menu of rights for people who are told you shouldn't be here and you're going back in the Returns Directive. And of course, what these member states could do, and indeed what they are increasingly doing, is kicking people out. So the alternative here is just to say, you should not be here, Ms. Dano, go home, because we cannot. So it would be the expulsion. Expulsion would be an alternative. So I just wondered where you sat on those kinds of difficult questions. Because we see now, Brexit is happening, so the UK is not discussing, but the other member states really want to restrict free movement rights. This is not going away after Brexit, so.
Just more a comment than a question. I think the panel this afternoon was composed in a very lucky way, because it gave me really a whole picture of the, let's say, of the state of social rights protection. What I take from these analysis of the three presentations is we have different levels of supranationalization. And where the fields are highly supranationalized, we have strong protection, social protection also, but not directly, but mostly indirectly. This was what Catherine Jacqueson said, that by the free movements of persons, you get indirectly also social protection. This is an old history which goes far beyond the Charter. So what did change with the Charter? Not very much. Still, the main emphasis is put on the four freedoms and other highly integrated parts of the. So indirectly, Maribel said the same thing. So it was never the social right immediately which was applied, but by way of a competence of the European Union in another field. And I think Paul Dermine, he showed very clearly that also the perspective union institutions often have belongs still to another world, if I would say. For example, the European Monetary Union is seen as a very technical thing. So there was no inclusion of considerations on social rights in it, because it was considered a specific instrument of integration. And so we have many blind fields still. And I like a lot this idea of introducing social impact assessment in all fields. And this means to change also the view from waiting until the effects come to prospective feeling and to see the consequences of dealing. I think this is still really lacking. I agree with this completely. And the next point, we have a Charter of Fundamental Rights, which contains this chapter on solidarity with social rights. And from this stem many, let's say, Erwartungen, many expectation, thank you very much, that there will come something. We will have protection, a complete protection of same level, but it doesn't take place. So the charter has been written in many parts. Think about the provision on the prohibition of death penalty and things like that, which are not applicable at all for the time being. I just perhaps exaggerate a bit, but it's like that. We have provisions which do not play yet the sufficient importance in our daily life, in the union life. Why? Because certain competences are not yet given to the union. And so I think once the European citizens see this charter, there are these expectations, and I think the union has now to work to make it really also to implement it in practice, because otherwise you will remain symbolic. Yeah? And we heard here a strong defense of much more active social policy and legislation. I think this can be combined with this view. Just that, this was a
kind of a broad but small question for any of the speakers. I wonder to what extent is there room for social rights protection at national level, like for instance in constitutional courts, as we can see that social rights protection has been lowered in the European Union. And connected to what Catherine said, how's this social pillar as a powerful addition for this new beginning, especially during this yes-no Brexit episode?
Linking to with something that Claire said, that the core feels comfortable with this secondary law. It says a lot about austerity measures and the crisis, the fact that for national states, some of these adjustments were really so important because they weren't a revolution. So it says a lot about how the national levels really fall, that they were so important, those cases, because nothing was holding. So actually there was going down, not only the national level, the EU level that was lower than the level that the national states had. So that said a lot about how fall down, because those cases were, for instance, the Pujante Rivera case, that was the only case in which a challenge of the labor law reform has been successful in Spain, which says a lot. So, because even if you go to national constitutional courts that have gone a bit farther than the Spanish one, than the Italian one, actually there are not so many cases in which has declared unconstitutional austerity measure. The Portuguese has been a little further, but it have patience. It said, not this year. Okay, the next ones, I mean, it says much with that this traditional indirect protection that has been through the years in the EU, not even this one worked till a measure was challenged.
Yes, thank you for playing devil's advocate, Claire, and for all your questions and the remarks, and very interesting. And it's true, I agree with you that there's always been some kind of challenge to free movement, and that there's how do you say, there's always been exceptions and so on. It's not something new. But the attitude, I think, especially of the court, is something recent. The recent attitude of the court is something new. That the focus has been very much on equal treatment and for especially workers, and with no possibilities of exceptions. And the same has been true or it has also been very generous in respect of the inactive union citizen, granting as much as possible equality and closing its eyes on the issue of lawful residency. And this has gone through until especially the Dano case, where there's been a turn, where it has been put things upside down, or it's reasoning upside down, saying, okay, equality, like the US court's main focus is now should be relegated to the second position, and the first position should be lawful residence. And there's always been a requirement of lawful residence. So I also agree with you, it's not something new, but it's something that they really tried, that the court really tried to set aside and use all kind of arguments saying, yes, but this person has a lawful residence according to international law, to national law, and that's sufficient to trigger equal treatment. This attitude is completely stopped, has completely stopped, and the reasoning is very much on the restrictions now that have always been there, and activating those restrictions. So this is something new, or not new anymore, but since the day, So yes, so that's my point on this, that there is some new things. Concerning your comment on the posting of work, is it all good? And yes, that's true, that it might have an impact on whether people will be posted at all, because now there's maybe not this advantage, and therefore it will be not good in respect of the posted workers. But still, I think that in the light of social Europe, and in the light also especially of social cohesion, is that this principle of equal treatment and equal pay for equal work should be the one winning in this situation, even though it's true that that might have an impact on the free movement and on the posted workers themselves. And then you also mentioned the issue of EU citizenship was introduced in the Maastricht Treaty, and something special, you could say, but now EU citizens are not seen as something special, but are more seen, as you would say, as migrants. So they are a little bit relegated on that, and I agree with you in this respect that free movement and migrations are a bit put in the same pot in this respect, that there is some animosity towards the two kind of movement of migration. And on the issue of Dano and the protection of human rights, I think that yes, it is easier now, since as a result of this ruling, to just tell people go home, and that's where the human protection should happen. It's in the home state and not in the host state, but it might, I think in practice this might be difficult, because also when are you lawful, when are you not lawful, is some issue which is not always easy to apply. Even though the message in Dano of the court is unlawful residence, it still hasn't defined lawful resident, even though it's applying restrictively the residence directive. So I think there's still some scope here in this respect. And people are actually moving. And so I think that in practice, this maybe you could say this should not be an issue, because people could go home, but if they don't go home, and if they're not expelled, then there should at least be there some kind of human rights protection. And yes, and then there's this issue, this very difficult issue and topical issue, is that free movement is contested, and that it's not only the UK, and it's a lot of member states, even the state where I come from, in Denmark, it's quite generous, and it's quite a wealthy member state, that there is issues in this respect too, where it's not about them so much being a burden, but why should people have access to benefits from day one when they haven't contributed? And the Danes, they have paid a lot with their taxes for many years, and people just arriving, they just, get an important surgery for free and so on. So there is this issue about this connection of free movement and access to the welfare state, which will not disappear. And I really don't know what's the best way. I think that we should still stick to equality and not sell out in this respect. But it's a tricky one. So there are different propositions on that, whether it's only those who are workers and not that maybe we could redefine the concept of worker and therefore also assure some kind of social cohesion and maybe stop the disappointment of some people. But I think it's a tricky one.
Yeah, very briefly, Claire, on your question regarding the easier nature of those cases, I agree with you. I mean, clearly, this Spanish case is classic EU case law, and it's much easier than, I don't know, Sotiropoulou and the right to social security. But in my view, it's a bit about that, but it's also about, I mean, contextual elements that, of course, the pressure on the court is much softer than it used to be. And also, I think that since LEDRA in 2016, there's been something going on, especially with Lennart's becoming president. I think that there's a will to react at least to these issues, or to take bolder stances on these issues. On the question of internalization and references to the charter in the two-pack, I agree with you. Clearly, there's been an evolution between the six-pack and the two-pack. In the two-pack, you find much more reassuring elements, references to the charter, to Article 9. But is this really followed upon in practice? I still have my doubts, as you overheard. And then finally, on the question on your question on national constitutional courts, of course, I mean, the economic pillar remains a decentralized pillar. The core of fiscal and economic policy making still occurs at the national level. So of course, there's still a great role to be played by national constitutional courts. Simply, what I've tried to argue in favor of is that there's currently an accountability gap at the EU level that needs to be filled, and the level of influence and of powers enjoyed by the EU is currently not matched in terms of accountability. So there must be a readjustment there. But of course, I mean, and I think the EU also ought to be more respectful of national constitutional courts. For example, the fact that negative decisions by constitutional courts may be elements that are taken into account in the review of the implementation of a memorandum of understanding is something that should not happen. It happened in Portugal. It almost happened in Greece, and clearly the EU should be more respectful of the decision made at the national level. So, but clearly, yes, big yes.
Well, thank you very much, Maribel, Catherine, and Paul, for your extraordinary presentations. Thank you also to this audience, and we'll see each other tomorrow at 9:30.